WTO can, it's not finished yet, negotiate to do something for the environment rather than for trade effects. So that's one possibility. Second possibility is to negotiate as part of what I will call the Copenhagen process, although I don't know if the agreement will eventually be finished in Copenhagen. This is to replace Kyoto, which expires at some point. So in the Copenhagen process, to negotiate as part of that carve-outs from the trade rules and get everyone to agree. This is really conceptually no different than doing it in the WTO. It has the added charm of having environmental ministers involved in the negotiations, which could be positive, could be negative, take your pick. The one slightly sobering thought for the trade law junkies here, the Bali Declaration refers only to minimizing the effects on trade. So implicit is, well, if we have to sacrifice some trade for protecting against climate change, so be it. And implicit in that is we'll run over the trade rules. But not to that has the advantage of a process that's already been launched. Whoever's elected president, with possibly one exception of the standing candidates, whether Democrat or Republican, will go ahead with that process and speed it up. So at least you have a process where something's going to happen. You don't have to start something in the WTO. The third possibility is do none of those, but simply muddle through, which is the default mechanism in trade law. This, in effect, you reinterpret, as I said, there are lots of things in the WTO which probably are inconsistent with what you want to do in climate change, so you reinterpret the WTO. The problem here is exemplified by what the WTO has already done, which is the appellate body decision in Shrimp Turtle. In Shrimp Turtle, the appellate body said that the U.S. could impose its views on a lot of developing countries. The appellate body chose not to say that it could only do so where in this case, the turtle involved was a Class 1 under CITES, and the appellate body decision mentions that. But it didn't say that's required. It didn't say the U.S. can only do so where there's an international agreement to which all the parties to litigation are a party. The appellate body also noted that the species of turtle swam through U.S. territorial waters, and this is a sufficient jurisdictional nexus. Well, apparently every air molecule in the world circulates the world every 2 months, someone told me. So we can regulate what Brazil does to the rainforest because the air molecules passing over the rainforest pass through here. And as I said, the WTO has already gone down this road. Maybe it's a good idea to allow that. Maybe no one else was going to protect the turtles. But what the appellate body did set no limits. It doesn't stop the U.S. from imposing its views in a lot of other areas as long as it goes through pro forma negotiations. Now, why is this a problem? It's a problem for two reasons. First, in general, when you say to someone in the WTO, you can do X, what you're really saying is big markets can do X. Because no one cares if Tonga Tonga's not the most recent. Who just came in? It was someone after Tonga. Stay with Tonga. There's a 152nd member now. But the 151st member, Tonga. No one actually cares if Tonga requires, if imposes a border tax, as Andy described, for climate change reasons. It's not going to change a lot of behavior. If Europe does, if the U.S. does, in 5 years, if not now, if China does, that starts setting standards for the world. The rest of there's a lovely saying, which I always trot out at this point. I don't speak French very well, so I'll quote from a French author of 100 years ago that the law in its majesty permits the rich and the poor alike to sleep under the bridges of Paris, but you don't find many rich people there. Well, here, the big countries, not all of them rich, China's not rich yet, will in effect set the standards. And the current WTO jurisprudence presumably allows that. I'm not going to get into whether I agree with Andy or not about whether Shrimp Turtle and the other jurisprudence allows the specifics of the proposal. If it does, it's a big problem because it allows big countries to impose their will on small countries. I lived in some developing countries, so I actually think that this unilateralism is probably a bad idea. Speaking as a patriotic American, though, to be really blunt about it, it also means the EU will impose its will on the U.S. We never like to think of ourselves as having the EU impose its will on us, so we never talk about it. But it does. The U.S. chemical industry is now adopting, having complained, I was counsel to it, about REACH, is now living with REACH. The EU is now regulating the U.S. chemical industry and indeed the world chemical industry. Why? Because it's a big market. Does REACH violate the WTO? Probably. You don't see anyone complaining. So in summary, yes, there are ways to adapt. They run a major risk of opening up cans of worms in the PPM area that Andy addressed, which gets you into worker rights requirements. The EU has, if anyone wants it, go back, it's called the Integrated Product Policy, a paper they put out about 6-7 years ago outlining how what they really wanted to do was regulate how every product sold in the EU is made, starting with the mine, the field, the forest, whatever, no matter where that mine, field, or forest existed. And that includes not just how it was made in terms of carbon output, how the workers were paid, how the animals were treated, everything else. That is not a world we want to get into. Thank you.
I think the two last speakers also. Thank you very much for this excellent presentation. Well, I think it's time for our commentator.
Thank you very
Nicole
much.
Collinson.
I think we've got a sort of a smorgasbord of opinions up here. Andrew set us up very nicely by giving us an overview of some of the precedent, I guess we could say, that we can turn to or not turn to when we're looking at what are the potentialities of international law and how those impact what might happen for environmental or climate change or whatever we want to call these new types of rules, regulations, or standards that may be implemented. I think that the comments that Gawain put out for us were the most optimistic, at least saying that if there are these types of measures that go out there because of the precedence of the WTO and the realization that it's supposed to be implemented in a fair platform, as Andrew had mentioned, that there are opportunities for the smaller economies to be able to have some sort of input or impetus in this. And I think Lynn was also taking a more optimistic look at this as saying, you know, what are the opportunities as opposed to how these initiatives or precedents that's already been set in the WTO might limit or restrict trade in that manner. And I think that there's an unknown here, and as Gary has pointed out, he sees the mischief that might be abound from all of the different countries who may set their standards or regulations or laws. So I think that there's really no one opinion here that we can draw other than to say that under the existing structures we have today, we don't have a framework which is going to regulate how we can move or what we can do. It's going to be probably, I think I agree with Gary, predicated very much on the larger economies and what they do and actions they take, which may set the global standards there and impact many of the other countries. But at the same time, I do have an optimistic bone in my body which hopes that some of the smaller countries may be able to use the WTO and that environment to try to ensure that they are treated fairly and able to benefit from some of these. So I think it's going to be very interesting to see what happens. I also believe that in the near term, we're going to see the environment playing a larger and larger role and impacting more strongly our trade regime, both domestically and globally. So I think that that emphasis may also be impacted by, depending on who is elected here in the United States or some of the other elections around the world. Because again, we all have mentioned it comes back to politics and will and what might happen by each of those industries. So I think this is a key area that we all need to watch. And as trade policy wonks, I think all of us are, it's exciting to see what might actually happen.
Thank you very much, Nicole. Before we start the questions and answer period, let me put a small word about Brazil here in this debate. Conventional wisdom in Brazil has always opposed environmental barriers to trade, under the assumption that this is just a disguised form of protectionism, which will be used against the Brazilian interests abroad. Now, what happened is that the Chinese are flooding the Brazilian market with Chinese products, and now you go to the Federation of Industries, and the debate there is, listen, these guys don't have the same environmental laws we have, and they don't have the same cost we have. So that's unfair competition. So I think the conventional wisdom is changing in Brazil, and the more imports we get from China, the stronger this voice is being heard from Avenida Paulista to the Ministry of Foreign Relations, and the diplomats may have to review some of their traditional negotiating stance in this area. But the question I would like to ask my panelists before I open the word to the audience is a development which seems very important in this area. The consumer is beginning to dictate norms in this area. It's not only governments, it's not only regulations, but a company which wants to sell its products, it must come up and say, listen, we're environmentally sound. And this puts a standard which is totally outside of the regulatory framework, the WTO rules. It's sheer market force. If you want to sell to me, I want this kind of behavior from you and this kind of assurance. Otherwise, my consumer will not buy my product. So I would like to ask our panelists, or at least two of them, let me just ask Andrew and Gary, to comment on that. And then I will open up the floor for the audience.
You're certainly right that if you think about what WTO law can and can't do, the theory is that you try to take the government out of the picture, and so if consumers are making choices and it's their choice rather than the government helping to dictate the choice, then markets will certainly respond to green products. I guess I'm cynical only because I see those two, the rich and poor guy under the bridge in Paris that Gary talked about. If you're rich, I think you can make those choices. If you're poor, I think your choices are really limited as a consumer. So I guess my concern would be that the consumers at the bottom end of the economic spectrum would not really be able to exercise it. They're going to get stuck with products that they can afford, which may end up being those that are the most harmful to the environment.
Thank you.
I agree with Andy. Let me start with the consumer dictating. It's certainly true. I had a fascinating conversation with a client, huge corporation, very well-known brand name, consumer products. Their products have almost no carbon footprint. The production processes have almost no carbon footprint. The per unit transportation is almost zero. And he told me that it's their number one priority is climate change. Why? Because their consumers insist on it. But that doesn't set norms. That dictates image. And at that point, you get into high possibilities of manipulation. Possibly the good news for poor people in this is that a lot of the visible targets, for example, if any of you have gone through the UK recently, there's an obsession with food miles. How far the food has gone, has moved. One of the newspapers helpfully pointed out that the lettuce, which had flown in from Kenya with huge numbers of food miles, used a lot less carbon than the lettuce grown in a greenhouse across the street. Food miles was not the sole result, and that you were putting poor people out of work. So it's a real concern. On the other hand, jet travel has a huge profile in terms of reducing carbon offset, and it should be, but actually it's a very small amount of total carbon use. Deforestation by slash and burn agriculture, which is by really poor people, probably has a greater impact. But the people who are slashing and burning out there aren't doing it by choice. It's as poor as you can get. And I don't think people worried about climate change have fully integrated the fact that a lot of the Most deforestation, for example, is by really poor people cutting down firewood because that's all they have. Someone's going to have to take that into account. This is not just, rich people have choices, poor people don't.
Thank you. Well, the floor is open, please. Questions are allowed, but also protests, whatever.
Thank you. One of the themes this morning was the theme of collision. Collisions between different bodies of law and collisions between different states with different objectives acting unilaterally. It seems that one of the big collisions happening right now is in the WTO negotiations toward an agreement on environmental goods and services trade. And it seems as though a big fault line has opened up there between Brazil on the one hand and the US and the EU on the other hand over trade in biofuel. With Brazil saying these negotiations need to be about market access for biofuel because that's what we and other developing countries are able to produce today and export to you. With the US and the EU on the other hand saying, no, we can't just open our market to this commodity product. We need to prioritize high technology goods that have some kind of an immediate ability to mitigate climate change problems. And given the Brazil focus today, I was hoping that someone on the panel could comment on what's happening in these negotiations. Does this collision between Brazil and the US and the EU on the other hand mean the end of these negotiations? Is there a way out of this impasse? If you could comment on that, that'd be great.
Can you please identify yourself as well?
Yes, my name is Behrendt Janssen with the law firm Aiken Gump.
Just to make you feel better about it, it's just the normal negotiating rhetoric. You wind up with a trade-off of cutting the tariff on ethanol X and Brazil cutting the tariff on certain goods it doesn't make anyhow by Y, and both sides come out claiming victory. There's a deeper rift, which is between mainly the US and EU, but also with some others, where the EU has been pushing very hard to define environmental goods by how they're made in the negotiation, and the US resisting that. And I don't know how, that's an ideological one. The one between Brazil and the US and the EU is just the normal noise. Personal view, but I'm sure I'm right.
Let me just introduce another matter here in the debate, and I think we have several more questions here. Oh, this is going to be hot. I'm sorry, Louise. I was just going to introduce also the matter of water. It seems that in the coming years there's going to be a water scarcity in the world. And of all the continents, the continent which has water surplus is South America. And that might be a major redistribution of trade simply due to water scarcity. But let me start. Who was the first one who rose? I think we have here a question.
Hi, my name is Flavia Seklas. I'm with Embraer, and you just mentioned jet travel. And we're working very hard on the environmental issue. It's become a high priority for our industry. But I haven't heard anything on when we hear about Lieberman-Warner or what the EU is doing. And all the debates I participate in, all the associations, anything about the WTO getting involved. So my question is, what would push this issue into the WTO? Will it be a high-tech item? Will it be the U.S. Bringing a case against the EU on emissions trading? How do you guys see this going forward?
Anybody in the panel?
If the issue, when you say, I guess I'm not sure what the issue is. If the issue is on aircraft engine emissions, generally on climate change.
Right.
It's interesting because one of my colleagues told me that in Bali, during a meeting with NGOs, there was a WTO official, and somebody raised their hands and said that all we want you to do is get up and leave. There's so much hostility in the environmental community to have the WTO involved in any way with this at a sort of a policy level that I think the most likely scenario is through dispute settlement. That is, it's probably a negative rather than a positive agenda item. It may well be on a subsidy matter or something like that. It's hard to see that governments are going to feel comfortable, given the way their environmental ministers feel and then their constituencies, that they want to negotiate this affirmatively in the WTO. But that's my sense just from the reaction that I heard about in Bali.
Okay, I'm sorry. Somebody from the panel want to comment? Gary?
Just briefly, I think that it depends on which NGO, because while environmental NGOs really do loathe the WTO, at least some developmental NGOs, I don't want to speak for Gawain, recognize the WTO tends to protect developing country rights better than pure power negotiations, even though the appellate body tends to bend to the U.S. and EU.
Okay, I'm allowed one more question here because of the time constraint. I think we'll take that at the end there.
Good morning. My name is Lawrence Kogan. I'm with the Institute for Trade Standards and Sustainable Development, ITSSD. And one of the interesting things that I've been looking at over the years, as Gary knows, is the interplay between regulations, standards, and trade, and environment, health, IP. In this particular case, the TBT and the SPS agreement seem to say that performance-based standards are preferred. I would think that this opens up a door of opportunity to interpret PPMs in a performance-based manner. There's nothing wrong with necessarily focusing on the way things are made if you can ground it in actual facts. Same thing with eco-labeling. Eco-labeling can be a very useful form of information to the consumer on point of purchase labeling, along with certification standards that can help industry define its products and its services based on fact. Now, there are a lot of point of purchase labels out there that say, as you say, that there's less of a carbon footprint. Prove it. There is no proof. There's point of purchase label on wood-based products in Home Depot that say that they're sustainably managed. Prove it. It's not shown. But these are not necessarily issues that can't be addressed and resolved. If you're going to go out there and try to market yourself as a company as environmentally friendly, then we should all try to find out a way to show through evidence that you are what you say you are. And I don't think the WTO would not countenance that type of process. In addition, climate change involves many different types of rules and regulations at the governmental level, and then at the industry standards level, you have a whole nother regime. And they're not mutually exclusive. Governments can put forth policy dictates that private standards bodies working within their countries can then move at the industry or at the NGO level to bind industry through supply chain. Now, if there's a government footprint on those standards under TBT agreement, under standards code as well as under the regulatory provisions of the TBT, governments can be held culpable under WTO rules. So transparency here is key as well. The EU, for instance, that I've been tracking for the last 5 years, has been looking at standards as a de facto way of governing through regulation. And the key about this is what policy objective is being pursued and how the rules not only appear on their face, but how they're actually being implemented. So I think there's ample opportunity. You also have environmental subsidies in the subsidy agreement that can be renewed. They expired. So you can promote the use and research and development of biofuels, solar panels, gasified coal, liquefied coal, nuclear power. All of these research opportunities and development opportunities are there. The question is, as Pascal Lamy has said, do you want to dig into the toolbox, be creative, and not undermine the rules as they now are? Any comments or suggestions?
Does anybody in the panel want to comment or agree to what was said?
Well, I tried getting USTR interested in Article 2.8 of TBT that you have to, standards should be based on performance. No takers yet.
Okay, unfortunately, time is over. We have to go to continue with our program. Do we have a small intermission here?
15-minute coffee break right now.
15-minute coffee break. Thank you very much.
So you have a big cheese over there now?
Yeah. By choice. I know. Actually, I got a promotion
Coffee.
too, and I'm totally hating it. Yeah, it stinks. So much more
I used to
management.
remember.
It's just a hassle.
Wonderful panelists. First of all, as many of you know, bilateral investment treaties are treaties by which states agree to afford foreign investors of other states certain treatment consistent with international law standards, matters like expropriation, discrimination, fair and equitable treatment. And then the states generally go further, and they offer aggrieved investors the right to challenge state action, including regulatory action, through neutral international arbitration. Often that's through the World Bank's Arbitration Center, which is known as ICSID. And 143 countries have now ratified the ICSID Convention, which establishes that arbitration mechanism. And 176 countries have entered into about 2,400 bilateral treaties, for the most part agreeing to this framework. Virtually every state in Latin America has BITs in force with a variety of other countries, and the United States itself is a party to about 10 treaties with countries specifically in Latin America, many other treaties elsewhere in the world, but 10 in Latin America, as well as the NAFTA, the CAFTA agreements, the U.S.-Chile Free Trade Agreement, all of which contain investment chapters that have substantially similar standards and remedies as do bilateral investment treaties. Now, traditionally, until very recently, Brazil stood virtually alone in the region as not having ratified any bilateral investment treaties, including any BIT with the United States. Brazil signed 14 such treaties in the 1990s, but it did not ratify them, in large part, I believe, because of concern over the institution of international arbitration. It signed 2 Mercosur protocols that included investor-state arbitration, but those were not ratified either. And what's interesting is that the stand in Brazil has been consistent even as the approach towards commercial arbitration in Brazil has changed. Brazil has developed a very modern and effective arbitration law. Its courts have adopted a more and more pro-arbitration approach, including in cases of state contracts by state-owned companies. And yet there's been no comparable revisiting of the issue on the investor-state arbitration side. So that's enough of my introduction. The purpose of this panel is to talk about the possibility of reopening discussions of a Brazil-United States BIT. We'll be hearing about the current thinking on this issue both in Brasilia and in Washington, whether there is momentum for change from the business communities in either country. We'll be considering whether Brazil's emergence as a significant capital exporter and not just an importer changes the dynamic in any way. We'll be discussing the traditional arguments in favor of BITs, attracting further foreign investment, enhancing competitiveness with regional competitors, and protecting one's own companies when they invest abroad, whether those make sense in the Brazilian context. But we'll also be exploring some of the counter-arguments that might suggest caution for Brazil. The notion that Brazil has an attractive enough economy and stable enough legal system that there is little incremental benefit of BITs, the concern about creating legal vulnerability, particularly in light of Argentina's many travails at ICSID in the last few years. And finally, we'll talk, I hope, about the implications of some recent moves by Bolivia, Venezuela, and Ecuador to pull out of either ICSID or the underlying investment treaties that those countries have, and whether those suggest a trend perhaps in the region back towards the tradition, the position that Brazil itself has, or perhaps do those suggest more reason for Brazil to reconsider if there will be 2 groups in Latin America with respect to the use of BITs and foreign investment, Mexico, Chile, Colombia on the one hand, Bolivia, Venezuela, and Ecuador on the other, with which group would Brazil like to be seen as aligning? So those are some of the questions our panel will be addressing. Given the shortness of time we have and the fact that you have all of the panel bios in front of you, I'm going to be very brief in my panel introductions, although I am joined today by an incredible array of talent on both sides. First, on the government side, we have Ronaldo Costa from Brazil. He is head of the Division of Services, Investment, and Financial Issues at the Brazilian Ministry of Foreign Relations. He's been a career diplomat for 20 years. He's been posted both to the mission to the United Nations in New York, to the embassy in Ecuador, and to the mission to the WTO in Geneva. And for the last 10 years, he has focused on international trade issues, and for the last several years been head of the Division on Services Negotiation at the Foreign Ministry, which is responsible for negotiations in the area of both services and investments. From the U.S. government side, we have Christine Bliss. She's Assistant USTR for Services and Investment, and is likewise responsible for overseeing multilateral and bilateral service and investment negotiations. She is, among other things, the lead U.S. negotiator in WTO services negotiations. She has negotiated the services and financial services chapters in the Morocco, Bahrain, Chile, Singapore free trade agreements, and in the CAFTA. Now, we also have two very dynamic speakers from the private sector. We have Arif Ali on the far left, who is co-chair of Crowell & Mooring's International Dispute Resolution Practice, as well as being an adjunct professor at Georgetown University Law Center and a recognized leader in both commercial and investor-state arbitration. Arif has particular knowledge of the Brazilian scene. Among other things, he was counsel to the investor in the famous Copel case, which first presented the issue to the Brazilian courts of whether a state-owned company could validly submit to international arbitration. Finally, we welcome Melita Hodgson of Miller & Chevalier, who specializes in international investment protection and arbitration. And before joining Miller & Chevalier, Melita was Associate General Counsel at USTR. She worked on almost all of the post-NAFTA free trade agreements, as well as on the current U.S. model BIT. She was the lead USTR negotiator for the first and only BIT negotiated under the new model, and that was with Uruguay. So those are our panelists. And to get the dialogue started, I'd like to ask Ronaldo first for a brief overview of the principal concerns that led the Brazilian Congress to reject the prior BITs that the executive negotiated in the 90s, and specifically which of those concerns are still likely to present continuing obstacles to a new round of negotiations today.
Thank you very much, Jean. Let me start by thanking ABCI and the other organizers of this symposium for the invitation to be here today with you. I'd like to start by giving a very quick historical overview of the issue. And basically, I would like to do this from the point of view of political perceptions in Brazil regarding the BITs in general, and how these perceptions evolved over time and what their impact was on their consideration. And I'd like to start back in the early 90s when Brazil was opening its economy, liberalizing and opening out to the world in trade and economic issues in general. And there was concern at that stage that FDI was not what we had been expecting and what was happening with some of our neighbors. The data gives us that between 1989 and 1994, FDI flows were limited to some 0.5% of GDP, clearly below what our neighbors who were already actively negotiating BITs were attracting. And the perception here was perhaps the BITs are a valid instrument to help attract foreign investment. And on the basis of this perception, negotiations started. As Jean has said, we concluded 14 of these instruments between 1994 and 1999. And the first of these got sent to Congress for congressional overview. 6 of them specifically were sent. The point of the matter is that when these instruments got to Congress, the political perception was entirely different. And it was for a number of reasons. And these reasons attracted attention from congressmen, and they gave a very detailed look at these instruments. I think the first reason that we have to highlight is the issue of some controversial arbitration agreements, arbitration results, particularly under Chapter 11 of NAFTA. There was some very visible arbitration result there, which kind of brought Congress's attention. The second point, I think, is the perception that these BIT are more or less negotiated exclusive by developed countries, from our point of view as a developing country, essentially in the interest of a home market economy, and not so interestingly or not so enthusiastically as a host market. And this perception came from the stalemate in the mine negotiations in the OCDE, and the fact that even in the early 2000s, when we already had more than 2,000 BITs negotiated, only 11 of those were between developed countries. Another fact that I think made for a decrease in interest in BITs was the fact that economic stabilization had kicked in, and a very extensive program of privatization was underway, and FDI flows had really jumped to 4 or 5% of GDP in those early years of the 2000s. So when these 6 BITs that were submitted to Congress were considered for the first time, a number of issues were raised by congressmen. And I can go quickly through those as Jean has asked, to give you an idea of the concerns Congress had from a legal point of view. The first was the question that they identified that the definition of investment was excessively broad, and that this gave rise to a certain, or to an uncertainty as to possible liability in the future, which, because the definition covered not only FDI per se, but any assets in Brazil, and including intellectual property rights. So there was a bit of concern that this was excessively broad. This is an issue. If I can go back and forth according to what Gina asked us to, what is still a major concern. This is a concern, but I think it is negotiable on a bilateral basis. They also raised concerns with the national treatment and most favored nation clauses. And this is basically, and if you go through all the reasons that I'm going to outline specifically, this is all a question of policy space for the government. The perception is that there has to be a certain amount of policy space for the government to direct or assist the development policy of the country through investment as well. One of the major obstacles and difficulties was exactly and precisely the investor-to-state dispute settlement clauses. This is something that even today I think is enormously difficult to contemplate getting past Congress, and the principal difficulty here is that the perception is that in having an agreement with an investor-to-state dispute settlement clause for foreign investors gives these investors treatment that is more favorable than that available to domestic investors. And this is, as I say, a major political obstacle for this kind of agreement even today. The other problem we had, which I think is solvable, is the question of expropriation. And there the standard clause on the prompt, effective payment and so on in freely transferable funds. I'm not sure about the exact language, but something like this hits a constitutional snag, because there is a constitutional provision which states that in cases of expropriation of land for agrarian reform, then payment is undertaken through a specific government bond, which is agrarian bond reform bonds. So there is a conflict between the BITs and the Constitution. But as I say, I think this is something that can be overcome. What I think is a bit more difficult is the question of the concept of indirect expropriation. This is something very, very sensitive in Brazil because, as I say, this is something that comes also from these examples we had that on the application of this, and this gives the government the sense, and Congress the sense that it's an open door. It's a blank check almost for the foreign investor. I mean, it's very broad and very imprecise, which gives some concern. And finally, I would like to address the issue of the free transfer of funds. This in itself is not a problem. The difficulty that was identified by Congress is that this goes beyond what we have agreed to in the IMF, which has the safeguard of the balance of payment provisions, which, I say, this is a very specific to the time when these were submitted to Congress, because we had just been through, or were going through, the crisis of the late 90s, and the perception was that there could be a need even then, even though Brazil was adapting to the IMF provisions in this field, that there could be a need for balance of payments provisions or recourse to balance of payment provisions in the future, and that's something that led to some caution. So, I mean, this is a very brief overview and of where we are today. We have taken note that these concerns we have are not exclusive to Brazil. There was an expert meeting at UNCTAD in June last year, in which we saw that a number of developing countries have similar concerns. And we have noted also that there is an evolution. There's this, not only the U.S. model BIT, but a number of countries have started trying to address especially this aspect of lack of precision in some of the provisions of the BITs. And what we have committed to do now, I mean, we've gone through an extensive interministerial process in examining the problems, which I'm not going to get into. But basically what I can say is that we have a mandate now from the Chamber of Foreign Trade, which is a ministerial group that examines all trade-related issues, to start looking at this again. And what we're going to start doing now is look at these new ideas, these new BITs, see how far they go to address our concerns, and see how we can move from there. Thank you.
Thank you. If I could just ask one follow-up to you, Ronaldo. Given that we're dealing with issues of political will and perception, as you indicated, I think for any state, the extent of political will is dependent to some extent on whether there is demand from a business community for legal reform of any sort. And do you see any impetus for change from the Brazilian business community, or is that sector mostly silent at this point?
Well, thank you. Basically, I'd have to say that there is absolutely no demand from the private sector for this kind of instrument. It's true that Brazil is increasingly an exporter of capital. Last year, for the first time, I think, we exported more capital than imported in investment. This could be topical. There's a very large acquisition by Vale in Canada, which perhaps distorted the number. But I think the tendency is clear that Brazil is increasingly an exporter of capital. The issue is, I think, that the private sector has not yet had any negative experiences. There is the case of Petrobras in Bolivia, of course, but it's different. That's a state-owned company and so on. But as I say, there's no, we have not felt in government a strong push from the private sector for this kind of instrument. I would say that the private sector would be much more interested in the short term in things like double taxation agreements, because that's a more immediate effect on their pockets, if I can put it like that. So the pressure is more on that kind of instrument than on an investment treaty. Thank you.
Thanks very much. Christine, what about the U.S. business community? Is there growing pressure to put these issues back on the table with Brazil, and where does the issue stand with the USTR's agenda?
Yes. I think, rather than using the word pressure, I would say there is a high level of interest among the business community, clearly. The President's Export Council stated in a letter that they thought that there should be substantial and measurable progress in pursuing the negotiation of bilateral investment treaties with each of what are called the BRIC nations for shorthand, and Brazil for alphabetical but also commercial reasons, is at the beginning of that list of BRIC countries. So I think there's no question that there's a great deal of interest in the business community. And I will note, though, that one of the things of concern, I would think, or at issue with Brazil is that U.S. investment has declined to some degree in Brazil. So while there's still a lot of interest, we note that, as our companies do, that the level has declined, certainly since the high watermark in the late 1990s. So without question, it's of great interest. And we do see that both greater protection for inward investment for Brazilian investors in the United States and for U.S. investors in Brazil is of great interest, and we think of economic benefit to both, because it encourages greater transparency, and investors have the certainty of the rules and protection of dispute settlement. And as you, I think, noted in your opening remarks, with the pervasiveness of BITs around the world and in other types of agreements like free trade agreements, I think that investors globally are looking for that as one of the major criteria when they look to a market and how attractive it is for investments. So yes, we do think it's very important, and we also think that were Brazil to decide that it was in its interest to sit down and discuss the possibility of a BIT with us, that it would really help to deepen our bilateral economic cooperation. But obviously, you know, there's a lot of issues, as Ronaldo laid out very clearly. But I will say a lot of those issues are one that you would not be surprised are typically ones that we do and have addressed in BIT negotiations. And I know there's some very tough ones there in terms of national history, but we're used to tackling those kinds of tough issues. So I think the ultimate question is, would a BIT really meet the needs of both U.S. investors and Brazilian investors? And I think our investment community believes that it would. And the last thing I would say is that I think as Brazil and other countries know, we are very willing and make it a practice to, as a first step, invite countries to sit down and have exploratory discussions with us, which may go on for a fairly long period of time and may never lead to an actual launch. We always hope they do. But we find those kinds of discussions to be very useful. We learn a lot about each other's laws. And I think in the case of Brazil, it would really provide an opportunity for us to explain the changes in the model BIT and the ways in which we think some of the concerns that you've raised might be addressed. Not, you know, wouldn't erase every concern, but I think pretty significantly in terms of defensive concerns that more and more countries have, and that we certainly share to some degree. So the short answer is yes, there's a lot of interest in the U.S. business community, and it's one of our top priorities.
Thank you. Well, one of the issues that you both raised is there an economic case to be made for a BIT before we turn to the question of legal obstacles? And I've heard perspectives on both sides. On the one hand, Brazil's total inward FDI, I gather, virtually doubled in 2007 over 2006. On the other hand, it is declining from some particular countries. And regional competitors such as Mexico also have booming economies and can offer investors the protections of international law and not just domestic law. So I guess let me put the question first to Arif. Have you seen either empirical evidence or evidence from your Brazilian clients that a BIT, or for your I guess your non-Brazilian clients as well, that a BIT might actually make a difference in incremental FDI, given that Brazil already has a very impressive track record in that area? And should Brazil be looking over its shoulder at regional competitors for that incremental investment?
Look, with respect to whether there's an opportunity cost for Brazil vis-a-vis Mexico, for example, I think that that's very hard to determine. There are different imperatives that are driving a U.S. investor to go to Mexico versus investing in Chile or in Argentina or in Brazil. I mean, those are business-driven objectives that are not largely conditioned by whether or not, I mean, to a certain degree, but not exclusively conditioned by whether or not the country has a signature to the ICSID Convention, or whether they're bilateral or multilateral investment treaties in place. I mean, as a person who advises companies in outbound investments and represents them in disputes, my experience has been that Houston-based energy and oil and gas services companies, or technology companies, or telecommunications investors in the United States and in Europe are not looking to define whether or not they go to Brazil based on is there BIT in place. I think that there are many other considerations that drive that decision. Principally, that Brazil is a very, it's a lucrative market, and so the drive for profits and the drive for exploiting that market is such that the risks associated or mitigated by virtue of having a BIT in place are not such significant factors. At least that's been, Christine, that's been my experience. I think that there is a question of need versus want. And does Brazil need a BIT? Do foreign investors need a BIT in order to be able to enter or look at Brazil as an attractive market? At least my experience, in representing companies, has been not so much the need. Now, would one want to have a BIT, or would one want to have a more resilient and transparent foreign investment law in Brazil? Would one want to have Brazil sign the ICSID Convention? You bet, of course. I mean, it's certainly, I think, what I would define it as an economic need or a foreign investment need versus a rule of law need. And overall, if one were to say that, look, Brazil as an emerging economy, as one of the BRIC economies, as an economy that that is now entering what might, going from a developing country to being a developed market economy increasingly, do you have a duty? Do you have an obligation? Do you have to show leadership? I think the rule of law imperative to me is perhaps one that is of great significance, because it creates a sense of confidence that ultimately is at a macroeconomic level and a macro-political level beneficial to Brazil.
I think, Melita, you mentioned to me recently that projecting an image of confidence in rule of law was one of the factors that in the Uruguay negotiations seemed to influence Uruguay's attitude. Could you expand on that a little bit?
Sure. I mean, I think I would agree with Arif that the issue really is more an economic. Obviously, Uruguay is in a different position than Brazil. And in the previous government, and I think this has continued even through with the more left of center government that many feared would sort of go backwards, they came out of the economic crisis and wanted to do certain things to attract more investment. And obviously you have certain provisions in these agreements that make it a little bit easier to sort of create reform. It's more in an FTA context, but also in the BIT context, you do have provisions like transparency provisions that make it a little bit easier to sort of continue out the reform. But even there, I would say the impetus was more of an economic impetus to get more investment in. But the benefit of having the accompanying rule of law provisions, and the idea that if you have those, it will make your country a more attractive investment site.
I'm sorry, you were nodding.
Yeah, no, I would just agreed with Melita's remarks, and I would just say I think that I can certainly understand in specific instances where a company is looking at a particular investment decision that it's much more driven by the prospect of profit necessarily than having a checklist before it of is there a bit and what other protections are in place. But I still think overall, and I think the fact that I think the U.S. business community has made it a priority in terms of a trade investment policy objective, that the rule of law point is very important. And there's a similar issue I would just point out that Ronaldo and I have also discussed in another context, and that is what is the impact, and it's very hard to measure, of the certainty of rule of law and increase in trade and investment. And yes, you can argue it's hard to say that X amount of dollars will accrue if you sign a BIT, just as in our negotiations on services in the GATS. Yes, there are many aspects of Brazil's economy that are open now. So the question is, why should those areas be subject to bound trade commitments? And it's really the same point. What is the value? It's the commercial certainty point. You know, whether you bind existing openness or whether you sign a BIT agreement, overall it's laying a much firmer foundation. So I would agree that's very hard to quantify in dollar terms. But again, I think both macroeconomically, but just even on a day-to-day basis, there's still tremendous value, even though it's hard to measure.
And may I think absolutely there are certain measures, and I think that for project financing, for borrowing with respect, for trade finance, the fact that Brazil is not perceived as having a resilient and transparent legal system, and whether that's, again, we live in a world of perception as reality, and so I don't want to get into that debate on commenting on the Brazilian legal system as such, although I've had some interesting experiences there. It's more a question of the perception is that there is yet to that the legal system is transparent, and so that perception then translates into a country's political risk rating, a country's credit risk rating, and then overall project financing, overall trade financing, borrowing to be able to use other people's money to do business in Brazil becomes more expensive a company. So in that respect, the rule of law point is an incredibly important one. But what I've found with our clients, and I'm sure Jean and Melida have had the same experience, is that in the absence of a BIT, which provides protections under international law, that there are other mechanisms, contractual mechanisms, in order to be able to obtain the protections that one might want or to mitigate risk vis-a-vis the contracting counterparty in Brazil.
But contract mechanisms can only go so far because they mitigate risks presented by the contracting counterparty, not, for example, necessarily state regulation. Let me ask a follow-up question really to all of our panelists. The notion of legal security, by definition, is addressed to the future, not the present. It addresses issues that go beyond today's economy, today's government policy, today's court's approach. What happens if there is legal or economic change? And we look today to Bolivia, Venezuela, Ecuador as countries in which there has been tremendous economic, legal, political change recently. To what extent the changes that are underfoot in those countries, to what extent do you believe that one may make it more important for investors looking at the region, at a country like Brazil, to say, I know that it's a secure environment today, but give me some assurances that I will be protected if it changes? Is that something that any of the panelists see as playing a factor?
Sure. I mean, the idea of legal stability is incredibly important, and particularly the types of investors that in heavy infrastructure, in the oil and gas sector, construction sector. I mean, they're involved in long-term projects, and today, given political cycles, long-term projects are anything, from my perspective, beyond 5 years, and one might even make the argument that that's a shorter time frame. So there is a significant concern about how the political cycles might impact an investment, and we've just seen it in Ecuador and in Venezuela and Bolivia. But I think that there, in the absence of a BIT or in the absence of any other mechanism, treaty-based mechanism, what we have tried to do is to put the risk of regulatory changes on the Brazilian party, basically through stabilization agreements, which are drafted in a way that say, look, if there are changes, if there are problems, and here are the host of problems, and these agreements can be 3, 4, 5 pages long because you're trying to effectively do what a BIT would ultimately substitute for, is to say, well, you bear the risk, and that gives us the right to terminate the agreement or seek other remedies.
Good point. Now, the opportunities that a BIT presents have to be balanced against the risks for any state in terms of potential liability. And I guess my question is, to what extent should Argentina's recent experiences present a valid cautionary tale for Brazil, or should Brazil perhaps take comfort from a country like Chile, which has many, many BITs in force, but actually has been hit with very few legal claims? So do BITs significantly affect vulnerability, or does this vulnerability flow from the stability of an economic and legal system? And I'll throw that open again to anyone who'd like to handle that.
You know, I think the whole Argentina example, unfortunately, sometimes it's not the best one for the region, despite what we're going through now. There's been a lot written about Argentina's history of sort of going through these cycles where it finds it necessary to take measures that perhaps are more damaging to foreign investors than what they thought the situation would be. I mean, yes, you can put in stabilization clauses, you can put in all of these things, but ultimately, and even going through ICSID, you know, we have Argentina today saying that, oh, well, this has to go through our Supreme Court. And it's like, well, okay, well, that wasn't part of the plan. Ultimately, you know, as Ira said, it's a business decision, and if you're going to be willing to go into a country knowing that this is all, nothing's perfectly guaranteed, this is all a possibility at the end of the day, then you're willing to accept that risk. I think there's certain kinds of investors, U.S. investors, who are willing to accept that risk because by nature, perhaps, of what they do, such as oil companies, they take a big risk up front on the idea that there's going to be a big reward at the end of the tunnel or at the end of the sea. You know, they're willing to take that risk, and some of them are more aggressive about pursuing their interests anyway and know that ultimately that's their own company political personality, so that they're not going to end up losing at the end of the day. Now, some of that we have yet to see, but I think for other companies and certainly other countries, the idea of a bit is very useful. There are ways to solve some of the problems. You know, I mentioned Uruguay before. I mean, when we were negotiating with Uruguay, it was such the contrast to what had happened in Argentina, sort of swallowing your medicine, and there may be development debates about whether or not they should have swallowed that medicine, but the fact is that they took one route that Argentina didn't, and they had concerns, and those concerns could be addressed in the agreement. You know, big concern being not having, if we want to call them rogue bondholder types coming after you later. Well, then there's a provision in the agreement that sort of takes care, to a certain extent, not fully, always protected essentially by the idea that as long as you're not discriminating between investors. But these concerns can be taken care of from the country perspective, you know, through negotiation.
Yep.
I just, quickly add. I mean, you can try and differentiate the two economies as much as you want, but the fact of the matter is that you can't just sweep the example under the rug. Argentina is next door, so everyone in Brazil is seeing what's going on with Argentina, and the fact that Argentina was applauded in the 90s for being an example of good practice economically, and notwithstanding this, it's suffering the consequences today. I don't want to get into the reasons why the problems are still persisting, but the fact of the matter is it's very politically visible that Argentina is going through these problems, and it can be attributed in public perception that this is due to the BITs. So you have to factor that into the equation.
That brings us directly, I think, to the question I was hoping to wrap up with first before we take audience questions, and that is the difference between old-style bits and new-style bits. That Argentina's bits, for the most part, were, shall we say, 1990s era bits, which, as you said, I think, Ronaldo, in your introduction, are perceived as being generally pro-capital exporting state rather than more balanced to host state interests, and have a lot of uncertainty about the definition of some of the legal provisions. As the U.S. itself has become a host state and a respondent state in NAFTA, and for a variety of other reasons, we've seen a shift in new generation bits that the U.S. supports to bits that are I think, more protective of host state interests, more likely to be pegged to concrete definitions, for example, in the indirect expropriation area, and perhaps less likely to lead to the kinds of risks that that Argentina has faced. And perhaps, Christine or Melita, you could address those issues.
Let me touch on it quickly, and then be interested in Melida's comments as well. I think you're absolutely right. I mean, one of the points that we always make when we sit down with a country and start to explore the possibility of BIT negotiations is the degree to which our 2004 model really does try and balance the concerns of the host government and its regulators. And I would highlight the first areas. I think there are elements of transparency that we have strengthened tremendously in terms of the process, the dispute settlement process in particular, and the degree to which the relevant regulators can participate in that process. And an example of this, and a very important example of this, which I think is relevant to the comments on Argentina, is the ability of the government to take measures for prudential reasons or to promote financial stability. And in that instance, I think there have been extensive improvements in sort of the level of review of that issue, so that if that is raised in the context of investor state, for example, there are multiple levels of screening and review that question has to be examined through, including starting with the relevant national regulators. So it's not the case that those regulators can be immediately bypassed in the case of a challenge, but there does have to be, as I say, quite a bit of screening. So I think that's an important improvement. I think the fact that you have to demonstrate that discrimination claims require that the two investors be in like circumstances is another very important kind of protection in terms of being concerned about the level of claims and the incidence of claims. There are other aspects, innovations that have been made in terms of discouraging frivolous claims. And I think that again, is something that's been very important, certainly to us. In the area of expropriation, I think there was also a real effort to try and clarify the kinds of factors that would be taken into account in determining whether an indirect expropriation has occurred, and you highlighted the sensitivity in that regard, particularly in determining whether it's consistent with domestic law, in our case U.S. law, as well as international law. So I think that's also very important. Also, minimum standard of treatment. We made some pretty significant clarifications. So I would just highlight, because I think they relate some of the original comments you made about your list of concerns. So those are among, I think, the more important ones. And Melida, those others you want to highlight.
Yeah, I mean, when you were giving your talk on all the things that were wrong, that Congress found wrong with the BIT, it was interesting because that was very much the experience that we went through after NAFTA. I mean, in my mind, of course, ironically, the U.S. so far has not lost a case in NAFTA. That may be because of the kind of cases that have been brought, but, you know, that's a different issue. Starting with the concern essentially about the idea that you're giving up your sovereignty in the investor-state process, some of the changes Christy highlighted, and it's essentially what was done was sort of rein in the tribunals. There was a sense that tribunals were not paying attention to what was being said. Now that partly came from a misunderstanding as to how international tribunals really operate. And what you see is provisions explaining expropriation. Here's how we want you to look at expropriation, and particularly indirect expropriation. Having annexes on the way you would interpret a minimum standard of treatment provision, the idea that you don't have an independent claim, you don't have a claim on that just because you claim some other violation like national treatment. Applying that also to the expropriation provision, and also bringing it in, narrowing it in the sense that you want to look at customary international law, not international law writ large, any agreement you can find here, there, and everywhere. Obviously, lawyers will do that. They'll bring in whatever they can, but a tribunal needs to focus on where the body of law that they should be looking at is actually coming from. In the dispute settlement procedures, I think one of the things that was particularly critical was allowing a tribunal, because part of what tribunals said and some of the arbitral bodies that they operate under don't necessarily allow, and I think there's a history of not wanting to get rid of a jurisdictional claim very early because this is your one shot, let's say. And the idea that if you have something in front of you where there's nothing to do for this claimant, get rid of it. Don't waste our money. And, you know, allowing the government to say, we want you to get rid of this. Look at, similar to a U.S. sort of summary judgment perspective, look at all the facts, look at the law. Is there something that we owe to this claimant? If not, get rid of it. And by the way, if it was just brought to harass us, we want you to give us attorney's fees, not something that is traditionally done in international arbitration. And I think it's interesting with the recent decision in the BSE case that the U.S. did ask for that and still did not get it, but that was not something that was, I won't say corrected in NAFTA, but it was not part of one of the interpretations that the U.S. government made. So I think we'll see a difference in the experience of governments in the new agreements, because there are provisions that do address what our Congress said, the idea that you have foreign investors having greater substantive rights than domestic investors, for example.
And just to reinforce some of the good news that I'm hearing, I will say just anecdotally in the last year that we've represented 2 sovereign states who not only got rid of claims early at the threshold, but recovered 100% attorney fees. So there is a possibility, there is a trend. We hope that more host states will see those cases and say the law is changing, tribunals are becoming much more sensitive to a margin of discretion for states in regulating and to the notion of cost recovery. Yep.
Just 3 very quick points. I think that this obsession with Argentina that Brazil has and other countries in South America, but particularly Brazil has, is because you just don't accept that Maradona is the better football player. but more seriously, whenever there's a dinner that is not going so well, you just let this particular topic sort of sit at the table, and you'll spend next 5 hours debating it. But I think that, look, the U.S. model BIT is not the be-all and end-all. And I know that this is all about negotiating leverage, but I do think that the U.S. model BIT is not a perfect instrument. I think it is an instrument that was developed with, in many cases, a reaction to what's going on in NAFTA. I think that it is somewhat unrealistic. And I think it's got some great elements to it, and I'm not going to comment on which ones I think are good and which ones are bad, but and leave that to your own judgment. But from my own perspective, I think that it is not the perfect instrument. I do think that countries like Brazil, such as India, and others which are emerging economies, that are strong economies, should develop their own model BIT that reflect their own perspective. I don't think that it's all about using the U.S. text as the basis for negotiation. I also think that the process of developing your own model BIT is one that will force you to think about the issues that need to be reflected in these BITs, and that would be then the subject of the negotiations. I'm not saying that you're not already doing this, but to concretize your thinking and to develop more sophisticated understanding of the nuances of investor-state arbitration, and particularly state responsibility, and what your ultimate risk exposure is within that context. And I would love to hear whether or not within the Brazilian thinkers on these issues, you are focusing on developing your own instrument and your own sort of white papers on these particular issues.
Thank you. It's a very interesting point. As I said, we did, since the BITs were withdrawn from Congress, we've gone through a very lengthy process. We've had 3 interministerial working groups looking at all these issues in detail. And the last step that we did reach is I won't say we have a model BIT, but we have, let's say, some parameters for each of these difficult elements in Congress of how far we think we could go in each one of them, which are basically, as I say, a parameter for any discussion with another country when we get down to discussing an investment treaty. So, as I say, not a model, but some guidelines.
That's great. We have, I'm told, no more than 10 minutes for questions, but I would like to open the floor now to some questions. I see a first hand in the back over there, and if you could each introduce yourself.
Good afternoon. My name is Lawrence Kogan. I'm with the Institute for Trade Standards and Sustainable Development. ITSSD is the acronym. And we've looked closely into Brazil and foreign direct investment, risk factor, asset operation risk, and how rule of law does make a very significant impact on whether investors are going to put money there in the first place, whether it be Brazil or Argentina, and then once they've made the decision to invest, what type of investment is going to be made. You've got different levels of investment, different types of investment, depending upon the rule of law, not only as it appears on the books, but also as it's being enforced and implemented. Now, there is an arbitrage between the way the rule looks on the books and the way it's actually being applied in the court, in the tribunals of that country, let alone being enforced in contract among the contracting parties to a business transaction.
Do you have a question for our panelists on this?
Yeah, the question is, when you say that the U.S. BIT model is not the penultimate BIT model framework to follow, you're actually opening up the thresholds for assessing risk based on different BIT models, because private property is the basis for investment in any country. And therefore, if each country can make its own framework on a BIT based on their property model, then investors may or may not have a risk depending on which model you use.
Okay, I'm not hearing a question, but if any of the panelists
That's the question is,
would like
how do you calibrate your risk assessment then?
Anyone like to address that?
As you would in any context, on a country-by-country basis, on a transaction-by-transaction basis, it is ultimately a business imperative that's driving whether or not you're going to invest, how much, what are the risk factors that are going to condition the return on investment, and how you calibrate that. So to me, it really is very individualized. I guess I have, from a purely academic perspective, and perhaps even a philosophical one, a problem with saying that whatever is reflected in the U.S. model BIT is in fact the ultimate standard, that it is the defining standard for basically all of the nations of the world in terms of how in terms of what state responsibility should be, and what should be what should be defined as the minimum standard of international law. As a principal matter, I agree with you that property rights have to be protected, but those property rights are being protected within the context of different instruments that have to be left to the individual contracting parties and the individual investor in its own assessment of what the risks are that it is willing to tolerate. I have a problem with over-regulation through a multilateral investment, agreement on investment, for example, or through any other standards that might be imposed by multilateral bodies, because I think that has a chilling and artificial effect on foreign investment.
There's a question right up here in the middle.
Marcos Orellana from the Center for International Environmental Law. Thank you to the panelists for an interesting discussion. My question concerns this idea of the rule of law. Again, these are public law disputes as has been framed, the panel has framed them, the state acting as a sovereignty, regulating in the public interest, but yet adjudication of these disputes occurs in private courts that balance public and private interests and adjudicate or award liability and damages or damages as a remedy. You may be acquainted or aware with the critique that these private courts or investment arbitration is neither impartial nor objective or neutral, because it depends on appointments, and thus arbitrators have a sense of business mind in adjudicating disputes. There is a business that goes on, and law firms are of course interested in expanding this area of business. Conflict of interests may arise in arbitrators and lawyers acting at the same time.
We need to move towards a question in the interest of time, okay?
And yes, I'm getting there. And they lack democratic principles such as transparency. Only the U.S. has incorporated transparency. The 2,000 plus bits or the arbitral rules do not. Or accountability, for that matter, no possibility of correcting erroneous decisions. So the question then is, are the courts in Brazil of to such degree inadequate as to justify this system of this external system of public law adjudication?
I'm going to leave that one to you. I mean, I have views on it, but anyway.
Well, I think my own view is that when you're thinking about BITs, the question is not for any given state, are its courts adequate or not? The question is whether investors would feel more comfortable not going to a national court in the first place, whatever its benefits or drawbacks. Having a system that is neutral by definition, because it is not linked to national courts, national judicial elections, national judicial appointments. And I make no comment on Brazil's courts whatsoever. The question is, do we want to move for certain types of foreign investment away from a system of adjudication solely by national court bodies?
No, I would agree that with Jean's point exactly. I think that it in no way is meant to cast aspersions or comment on the adequacy of domestic legal system, and it is to set up an independent alternative, which we think is very valuable and goes to the point of why one of the key objectives in our bits is to provide what we believe to be the highest level of protection possible to investors in both directions. As well as providing for guarantees of transparency and other elements to try and make that process as fair and transparent as possible.
Yeah, if I can add one thing, Jean, I mean, one of the elements that you're missing about having a separate court, and I've heard all those criticisms before. The reality is that and I'm not going to say that the U.S. bid is the ultimate bid, but at least one of the issues, and it may be that it is the ultimate for U.S. investors, because it may be that European investors don't care if there is a private, hotel room arbitration. But one of the things you're missing is that when you have a procedure like this, you take away some of the political issues, particularly with respect to Latin America and the U.S. history with Latin America. It takes away the need for the state to get involved and own the claim. That's not to say that in certain circumstances, and we may be getting to that point, it won't do that. But you're missing that element that this is essentially, it's a state and an investor, but it's essentially a commercial transaction. So allow it to go through the process that a normal commercial transaction would go through and not have to get politics involved in it. I think that's one point you're missing. Another point I'll just add about the whole idea that, Christy mentioned we have more transparency. When this was first introduced, not because it was part of NAFTA, but because there was so much political pressure to do it, there was a live feed at the World Bank for anyone who wanted to come and hear. I believe it was one of the Methanex hearings. First day, 38 people. By the afternoon, half of those people had disappeared. Query how much interest there really is, or if people just want to have a baton to hit at the process.
Well, and the ICSID rules have in fact been amended, for example, to allow for third-party intervention. And I agree with the question of transparency. Absolutely, we need in these public disputes that involve state action, that they need to be evaluated within the court, within a more transparent process. But I don't think that process is one that has to take place necessarily within a domestic judicial system. I leave you with the question of whether Petrobras would want to be in the courts of East Texas. I can pretty much assure you they wouldn't. In the same way that clients that we've represented would not want to be in the courts of Curitiba, where we have had very bad experiences. Rio, Sao Paulo, no problem. New York, Washington, LA, Chicago, Houston, no issue. But when you get into areas where more nationalistic or closed-minded views may be driving a decision, then I think even for the Brazilian investor here in the United States or an Indian investor here in the United States, there are some severe concerns that arise.
I've been told that we need to draw the panel to a close. I'm sure many of you have outstanding questions. I'm sorry we can't accommodate them, but I want to thank our panelists who've been terrific. Whoops. I don't know what I just did under there, but it was great.
Oh, that's all right.
Oh,
That
it's
stuff is
the electronics. Okay. Terrific. Thank you both.
If you just bear with us another 5 minutes, just a few minor closing comments to close the session. Let's first of all thank all our panelists for today. Thank you, Jean. I would like to, before I thank our hosts and our sponsors, I just want to give you some very exciting news. the BCI Institute has just concluded several cooperation agreements that I think you need to know, with the Federation of Industries of the State of São Paulo, with IBMEC, the university in São Paulo, with the Getúlio Vargas Law School in São Paulo, in Rio with the Center for Brazilian International Relations, SEBRI, with the Federation of Industries of Rio de Janeiro, and also with Getúlio Vargas Law School in Rio, and finally with the Federation of Industries of the State of Rio Grande do Sul. So stay tuned. We have several initiatives that will come out of these cooperation agreements, and I want you all to be aware and participate with us. Finally, I just want to thank a few people. First of all, to Paulo Sotero and the Brazil Institute, the Woodrow Wilson, for once again hosting us here and giving us all the support, particularly to the help from Alan that did a fantastic job. I also like to thank my team, which without them this wouldn't have happened. So I like to name Maria Júlia Florencio. I like to name Ana Carolina Weber, Isabel Acher, and last but not least, our promoter and marketing director, Daniel Aon, for all these, for the promotion that was very successful at the end. And finally, our sponsors. Without them, this wouldn't have happened, so I need to name them. And thank you, Crowell and Mooring, Felsberg and Associados, Miller and Chevalier, Sidley Austin, Sandler, Travis and Rosenberg, Thompson Hine, Verano Advogados, of course, Arnold and Porter, the Embassy of Brazil for the support, the U.S. Business Council, César Ibrac from Rio de Janeiro. I'm sorry, from Brazil. Their headquarters in São Paulo. My God, I'm gonna hear afterwards. You know that. And just for the record, Pelé is better.
I agree.
Okay. And thank you very much. We'll be back here. I think the Friday before Carnival next year is February 25th. So stay tuned. You'll know soon what the program is going to be for next year. And thank you again, Paulo. The floor is yours.
Well, not only Pelé was better, he never scored a goal that needed explaining for 20 years, where they were all absolutely legitimate and glorious. Thank you again. At the start of this event this morning, I on purpose refrained from doing the welcome and including the ABCI, because I wanted the ambassador to do that, and I wanted precisely the ambassador to embrace the ABCI the way he did today. I think it's very important that the embassy acknowledges the work that you all have been doing, and my hope is that a year from today, on a new Friday of Carnival next year, there will be obviously a new administration at work in Washington, D.C. We will know by then what happened to the U.S. economy, its impact on the world economy. It will be much clearer. Hopefully, John Huneman will be proven right, and the negotiators in Geneva will have moved closer to an agreement, and we will be able then to go back to the original format of this conference, which is a full-day conference, because then I think there will be a lot to talk about. Before you go, I wanted to include in the thank yous Priscilla Yon from intern from the Brazil Institute, and works with Ala and with me. The video stream of this conference will be available in a couple of weeks online. Also, the report of the conference. I wanted to call your attention to our next event. We will be off-site at the Convention Center in the context of the Washington International Conference on Renewable Energy. We will have a panel with UNICA State Department, Brazilian Embassy, and others, Brazilian government, on 1 year after we started this biofuels love affair, what happened. We are curious about that, and we want to have the private sector and the two governments together. So you are all invited to attend. You will also see in the next few weeks, with the report of this conference, various reports. We were a little bit backlogged in issuing reports about various activities we had. And if you have time, I would invite you to go to the fifth floor and the fourth floor of this building and take a look at the exhibit, Amazonian Photography, that we opened 2 weeks ago here. It's a work of journalism. As I said, and it's quoted somewhere, it's not trying to show beautiful Brazil. Yes, Brazil is very beautiful, but the Amazon region is a challenge to us, to all Brazilians, and we have a photographic exhibit that sort of illustrates that. I would like, if you have a chance to visit it, it will be there until mid-March. You are welcome to take a catalog with you. And then, I hope that you'll come back very often to our programs here at the Wilson Center, not only to the Brazil Institute, but to the 20 programs that we have here. This is your home in Washington, and I'll see you, or we'll see you, Friday of Carnival next year